depending on where you are. Good morning or good afternoon to everybody joining us today. Continuing with a topic that we've talked about previously at different stages, the audit and response, dealing with recoupments, dealing with Medicare, Medicaid audits, private commercial audits, something that we are seeing more and more here in our office. Today's seminar topic, we're going to deal with the next stage. We've previously talked about what happens when you initially get an audit from a healthcare payer and how to deal with those audits, how to prepare for them, and how to deal with them. They typically come in the form of a record request or a review. And then after that process starts, if the payer determines that you have been improperly paid or are not entitled to be paid for a particular claim, how do you deal with it at that point? This can come in two different basic forms. It can come, some audits can be on a prepayment review, where before you're paid, there's a review of records, a review of information, and the payer makes a determination you're not entitled to payment or partially not entitled to payment, or as a post-payment review after you've already been paid in the form of a recoupment, hence our title. Here's the agenda for today's topics. I'm going to do a little bit of discussion on just some background on how you end up in the appeal process, usually as a result of a potential adverse outcome or determination by a Medicare payer, a Medicaid payer, one of the contractors working for them, or a commercial payer. I want to start, however, I have a little bit of an introduction, but I was looking at a particular case recently in connection with some research I was doing on this, and I want to read an excerpt from a case from a couple of years ago. And here it is. Executive agencies today are permitted not only to enforce legislation, but to revise and reshape it through the exercise of so-called delegated legislative authority. The number of formal rules these agencies have issued, thanks to their delegated authority, has grown so exuberantly, it's hard to keep up. The Code of Federal Regulations now clocks in at over 175,000 pages. And for background, the Code of Federal Regulations, or CFR, that's the publication of regulations of federal agencies. No one seems sure how many more hundreds or thousands or maybe millions of pages of less formal or sub-regulatory policy manuals, directives, and the like might be found floating around these days. For some, all of this delegated legislative activity by the executive branch, that's the president, and its delegated department heads, raises interesting questions about the separation of powers. For others, it raises troubling questions about due process and fair notice, questions like whether and how people can be fairly expected to keep pace with and conform their conduct to all of this churning and changing law. In the Federalist, John Madison wrote, "It will be of little avail to the people that the laws are made by men of their own choice, if the laws be so voluminous that they cannot be read, or so incoherent they cannot be understood, or undergo such incessant changes that to no man who knows what the law is today can guess what it will be tomorrow." And what if the problem is even worse than that? What if we reach the point where these legislating agencies don't know what their own law is? And then this case goes into a discussion about CMS, the Centers for Medicare and Medicaid Services, and the thousands of regulations that CMS has issued, particularly in connection with payments, audits, recoupments, the entire audit process, talking about sub-regulatory publications that are not in the CFRs. Think of local coverage determinations and national coverage determinations, and how many of those you see. With that in mind, we're going to dive into this topic, but we could talk about this particular issues for hours, and probably over the next several months, I'll pick a few things out, maybe talk one time about suspensions, one time about injunctions, if you're trying to halt payment during the appeal process, or halt recoupments during the appeal process, and what the state of the law is there. Today, I'll touch on some of those issues. If you have questions, let me know. If any of these particular issues hit home with you and you want to reach out and contact me otherwise, please let me know as well. So let's talk about the audit process. So to understand, first of all, how to appeal if you get, or how to challenge an adverse determination decision. You have to take a look at what system you're in. For Medicare audits, the types of refusals of payment come in two forms. It could be as a prepayment review or as a post-payment review. So listed on the slide are the different contractors that conduct these types of reviews. The MACs and the UPICs do both prepayment, post-payment reviews, and other contractors do post-payment reviews only. Typically, what will happen in the normal scenario is that you'll get a post-payment review of a certain number of claims, and if the post-payment review error rate comes back high, you may be put on a prepayment review, and you could ultimately be put on suspension. In Medicaid, understanding that Medicaid it's a federal program, but it's administered by the states with under guidelines from the federal government. The federal government contributes to the financing of the program, and then states contribute. So each state may have different systems for audits and appeals, but they're generally going to look the same because of the federal overlay of that system across the country. Here in Florida, our Medicaid system is governed by the Agency for Healthcare Administration, AHCA, and then we have a Florida statute at Chapter 409 and Florida rules that apply to Medicaid generally. Medicaid also has a system of audits to identify and recover alleged overpayments to providers. And all of this, by the way, this discussion will make it a little bit a significant distinction for our purposes and what we do. We generally don't represent beneficiaries, the patients or the recipients of services. We represent providers who have provided the services and are trying to get paid. There is, of course, an appeal process for a beneficiary who's denied payment or denied a claim to appeal that claim. Sometimes that system looks similar to what the system is for providers. Sometimes it's substantially different. But all of our discussion, of course, today is talking about providers of goods and services who receive payment from payers, commercial payers or government payers, and what the audit and appeal process is with respect to those parties. Finally, talking about private audits, these will be generally under contract authority. So when you sign up with a particular third-party payer, is it Blue Cross or Sunshine Health here in Florida or United Healthcare, you sign a contract with them, and under that contract there are I've talked about this in the past, when you sign contracts with third-party payers, certain things to look out for, such as the definition of medical necessity. It may not conform with the definition of medical necessity as you generally know it, or as it's found in certain case law or found in regulations that are applicable to Medicare and Medicaid. So you need to be aware of that. That's a typical challenge in the audit process. And you also should understand that when you're in a private system with a private commercial payer, your dispute resolution procedures, your appeal rights, all of that is going to be generally governed by the contract. There is, of course, some statutory authority and case law that applies to that. In Florida, we have insurance statutes, we have an insurance fraud statute, but generally the first place you're going to look for the procedure is in the contracts themselves. All right, so moving on to discuss the potential adverse outcomes and consequences if you are subject to an audit and you get a bad determination. Of course, there can be denial of payment, or you can be subject to a demand for repayment or a recoupment demand. That can come from a Medicare contractor, it can come from Medicaid, it can come from a private payer who has determined that you received funds, you received payment for services that were submitted, and for one reason or another, you're not entitled to keep those funds, and you've got to return part or all of the money. That's the recoupment. You could be placed on a prepayment review. I talked about that a few moments ago, where once there's a post-payment audit that determines you've been overpaid, now you won't be paid going forward until that payment is reviewed and approved. payments can be suspended. You can be debarred from being entitled to accept Medicare payments or be in the Medicare system or Medicaid. And a private insurance company can as well remove you from their system if they determine that you've engaged in some activity that they allege is fraud or some improper conduct that justifies removal from that private payer system. And in the most egregious circumstances, if you do engage in fraudulent conduct, or if you're alleged and it's proved that you've engaged or substantially alleged under some circumstances, maybe not even proved, you can be referred to prosecuting authorities such as OIG, that's the Office of Inspector General in the federal government, or other law enforcement officials, such as state authorities in whatever state where you are located. So now you've gone through the audit process, you have gotten the results back, you've gotten a letter from whoever conducted the audit. In Medicare, that's going to be a third-party contractor. In Medicaid, it might be a Medicaid investigator, it may be a state agency, or it may be a managed care provider, or in the commercial system from the insurance company itself. Couple of preliminary questions that you should always ask yourself. And this really goes for almost any time you're going to dive into the world of anything that looks like litigation or administrative procedures to resolve disputes. You need to ask a couple of preliminary questions. And the first is, what caused this negative result? What caused the adverse outcome? And is it justified? Is it an actual error? Was payment denied? And when you look at the rationale, you realize, okay, yeah, we didn't do that properly, or we didn't bill that properly, we didn't code it properly, we didn't supply the proper evidence. What's the reason for the adverse outcome? And then, with that, is it correctable? Is it an oversight with paperwork? Did you not submit all the required records for the audit? Was a form not properly signed, but that can be corrected through some type of attestation? Look at the reasons and look at what would be required, whether that can be corrected or not. And then that will take you to your next decision of whether or not you should appeal in the audit if you've gotten a bad result. Is this something that either the contractor or the reviewer got wrong, or is it something where they caught an issue and you can correct it? Or if they caught an issue and even though there's an issue, the determination that they made was incorrect, either because they have disallowed too much of the payment, or because whatever the error was inconsequential, or did they miss something in your records? So take a look at those issues and then determine whether or not you should appeal. And part of this will depend on what the appeal process looks like. In Medicare, for instance, the first level appeal is submitting a redetermination, and that's relatively easy to submit. So you can submit for redetermination, level 1 appeal, simple process, and then you get the results back on that. You're at level 2, and then you have a little bit more decisions to make. And then that's the third question here on the slide: how far should you go? So staying with that same system, because it's one that most folks probably that are watching this today maybe have some experience with, or at least you have experience dealing with Medicare. You have your level 1 redetermination. At level 2, you have a reconsideration, and the reconsideration is done by a third party, a qualified independent contractor, and that there's a 5-level appeal process, 4 steps within the administrative process, and then level 5 takes you to the court system. By that point, your appeal process, you're probably going to, by that level of appeal, most parties are going to be represented by counsel. That's not going to be inexpensive. There is a lot of time involved. There's a lot of work. And in particular, at level 2, that's an important part to point out, because in the Medicare system, all of the evidence that you have to support your claim, if it wasn't submitted with the original records and it wasn't submitted at level 1 redetermination, has to be submitted at level 2. If it's not, you waive it. So if you do your level 2 reconsideration, You get the results back, you still have an adverse result. Now you want to go appeal to level 3, which is an administrative law judge. And you want to set your hearing with the ALJ, administrative law judge, and you go to the ALJ hearing, or you're preparing for the ALJ hearing, and you want to submit additional evidence. Well, it's too late. There's some exceptions if there's a reason for that the evidence wasn't submitted, but as a general rule, if you haven't submitted that evidence by level 2, you're not going to be able to rely on it further in the appeal process. So that level 2 process, in our view, in our experience, is oftentimes the most, that's where most of the work needs to occur. You identify the issues at level 1, and you're really gathering all your evidence at level 2. Very similar to a regular court process, where if you are in court over a dispute and you haven't submitted evidence at the court level, you won't be able to rely on that evidence in your appeal. So you have to make sure you build your record. So here I've talked about the appeal process in Medicare. This is what I was just talking about here, level 2 with a qualified independent contractor. The level 3, if you can go in front of the ALJ, there's a limited amount of time under the rules during which you are entitled to have your case heard by the ALJ. And if the ALJ does not, if you don't get that hearing within time, and recent years, there's been a significant backlog, you're entitled to then immediately go to level 4 and take your case to the appeals council in Medicare. And then again, if at level 5, if after you go through those 4 steps, if you're not satisfied with the result, then you can go to federal court, who will then review that claim at the court level. Medicaid has a separate process, and again, that could vary from state to state to some degree, and it also may be dictated by contracts. If you're dealing with a Medicaid, a commercial insurance company that's providing Medicaid managed care, as we have here in Florida, you may be dealing with the contract dispute resolution procedures. Oftentimes there may be a mandatory negotiation or mandatory mediation, and then there's an administrative process or an arbitration process to resolve that. So again, it's not likely that you'll be dealing with this in court. You'll be dealing with it in another forum, but ultimately these things can end up in court. And same thing with commercial insurance, as I just mentioned. Commercial insurance, managed care, or other commercial insurance will be dictated by the terms of your agreement with the insurance company. All right. So we're going to talk over the next several slides about some of the most common issues that we see on appeal, and generally speaking, how to deal with these. First one is signature issues. These can be missing signatures. I've seen this a couple of years ago. I had a situation where we dealt with, it wasn't a missing signature. It was interesting. It was a Medicaid appeal where claims were denied because there were not proper referrals from the physician to the company that I represented. Was a company that provided medical services, where all of the beneficiaries were referred by treating physicians, and then care plans had to be updated periodically throughout the year. Every couple of months, you had to have a new plan, had to be signed off by the physician. And after an audit, several of the claim submissions were rejected, and my client was instructed to pay back, or there was a recoupment demand for a significant amount of money, several thousands. It was over $100,000. So the first thing we looked at is, okay, what is the Medicaid? What are they looking at with the audit? Same as the process I told you to go through when you go through appeals. What's the reason for the adverse outcome? Is it justified? And this is what was crazy, is the reason for the denial was that the care plans were not signed by physicians. We went through the care plans, and the care plans were all there, and they were all had signatures on them. So we went back and forth with the auditor, and it turns out that the auditor had rejected the claims because the signatures were illegible, according to the auditor. which almost sounds comical, because if you look at medical records or legal documents or almost anything else and try to read signatures, and you don't have more information to go on besides the signature itself, and you try to read it, you might find it impossible to read that signature. But that was their position. Well, the signatures are illegible, and therefore we have treated it as though there was no signature at all. Well, that was something that we could correct. One, we could argue about whether or not there was a signature, whether it was legible, whether it was legitimate. But the question I raise is, well, what if we go to the physician and have the physician sign an attestation or an affidavit, declaration, some sworn statement that says, yes, that's my signature. I put it on that form, and the physician swears to that today. And we have ID or whatever other information a contractor needs. And that was sufficient to resolve that issue. So sometimes it's a fairly easy issue that we can work through, almost laughable that we had to deal with it in the beginning, but easy to correct. So illegible signatures, missing signatures, you might try the same. If there's an oversight on a signature, and you can go back and you have documentation that shows that that whoever signed this, that was an oversight, perhaps there were several forms that were signed at the same time, and one signature line is missing, and you can go back and talk to the person. Do you recall signing these forms? Or is it your regular policy procedure to sign these forms in this particular order? And is this yours? Is this yours? And you go through and confirm that all the other information matches up with that person's recollection or that person's records or that person's regular course of dealing, as long as it's not dishonest. I'm not in any way suggesting that if you don't have a properly signed document, you go back and you fill that in and just have somebody sign it after the fact. What I'm suggesting is that if you have a document that that is otherwise credible and has all the required information and signatures, sometimes you may have just missed a signature. And I'll give you a basic example of this, or an example of a contract clause that deals with this. Most contracts that you sign, if you sign a mortgage, loan documents, anything you sign with a bank, with a financial institution, especially anytime you borrow anything, you're going to see this. Contracts for real estate, you're going to see a clause that looks something like a further assurances clause. It may be called something else, but in my contracts, when I write it, I usually call it further assurances, further acts. And what that clause says is that for any other ministerial acts that need to occur to accomplish the goals and the tasks, the purpose of the contract, the parties agree that they'll do that. That covers specific things like you're sitting down, you're buying a house, you're signing all the documents if you've ever gone through that process with the title company, and somewhere somebody, the closing agent, forgets to have somebody sign a document. Well, you're not going to be able to keep a house with a loan or a mortgage on it. If there's a missing signature, you're not going to be able to say, well, oh, you never got me to sign the document, so I'm not going to sign it now. I'm going to keep the house. I'm going to keep the loan. I'm going to keep whatever. It's not going to work. And that further assurances clause is designed to have you go back after the fact. Look, you signed all these other documents, but this was just a ministerial oversight. You can do that when you have affidavits. There's certain documents, a mortgage is an example. There's other documents where you'll have to have witness signatures and notary signatures on there. The notary signature serves a different purpose than the witness signature, but in some circumstances, such as in a mortgage, one of the witnesses can be the notary. So you can sign as the notary and you can sign as the witness. So a common way to fix deeds that are missing perhaps a witness signature is to go back and see if it was notarized, and if the document was notarized, ask that person if they were present at the time it was notarized and witnessed the signatures, and you can add that witness signature after the fact. It's not fraud, it's just a correction. Similar with attestation issues, again, I've used this to go back and deal with audit issues where a document wasn't, medical records weren't authenticated. So that's something where it comes up where you submitted unauthenticated medical records. There was no signature on the records. Sometimes this happens because of EMR systems and digital signing. You get the physician to sign an attestation that says, these are the records that I submitted. They come out of my EMR system. I believe that they already had a digital signature, or there was a digital signature, or there was a digital imprint. and the physician affirms through this attestation that this was, in fact, documents that they had prepared and reviewed and are authentic and came out of their system, and you correct the issue that way. And there's a note here, I have here somewhere in the slides, there is in the program integrity manual for Medicare, there is a procedure for authenticating illegible signatures, correcting signatures. So follow the process outlined in this manual if you need to deal with that. All right, so probably the most common reason, other than maybe ministerial issues, records that weren't provided, or signature issues, things of that nature, missing documents, the most common reason that claims are denied is due to lack of medical necessity. And this can come in many different forms, and sometimes the medical necessity is defined by specific requirements that might be in regulations, or more common in a national coverage determination or a local coverage determination, or some stipulations to say, okay, in order to bill under this code or bill for this procedure, you must also confirm, and the medical records must show that you've done, A, B, and C in order to bill for X or Y. That's very common. So we start with the general rule in Medicare that expenses must be supported by reasonable and necessary diagnosis and treatment of an illness or injury. And it can't be just for the convenience of the patient. It has to be reasonably necessary for clinical purposes. So I've got a few different quotes and definitions that are up here on the slides that you're going to see. The last one come right out of the statutes. Here's other descriptions of medically necessary, and here we see a description: medically necessary services are those which a physician exercising prudent clinical judgment would provide to a patient for purposes of preventing, evaluating, diagnosing, or treating an illness, injury, disease, or its symptoms, and meet these particular standards. Generally accepted medical standards, clinically appropriate. Those are the types of words and phrases and descriptions that we're looking for to support medical necessity. But then we have to go a step further. In medical necessity, we have to look at if there's a reason for particular billing instances or issues. Is there something that prohibits services from being paid because they have been determined not to be medically necessary? That's often combining certain billing procedures, like providing, let's say, a vaccine in connection with a evaluation visit for a patient. Maybe you can't bill the two of those together. You have to bill one or the other unless there's a separate instance. So it gets a little bit technical, but we want to start off with, and especially if you're dealing with commercial payers, how do you support medical necessity? Well, you support medical necessity by showing, by having good records, by having records that reflect the necessity of the services from a clinical point of view. And then once the clinical necessity is established, those items are in the records, and so those records can be provided to the auditor. So the two issues we're going to look at in connection with an appeal is, one, is the clinical necessity there? Was it determined by the whoever provided the treatment of the services? I'm using physicians oftentimes, but it could be another service provider. So was there a clinical necessity or clinical reason for the services? Are they justified? And if the services were justified, are they documented? So that's two different issues that we're looking at in connection with every time we're reviewing medical necessity. I include this it's sort of some thoughts here on medical necessity, the difference between what you see in federal regulations or in state law and what you see in a contract. Again, I'll come back. I'm kind of hitting on this point right in the middle of this discussion here on medical necessity, but I want to make sure that people realize that when you're negotiating a private commercial contract to join a healthcare system as one of the providers, look at the definitions of medical necessity. Sometimes they'll be in the contract, sometimes they'll be in the manuals. make sure that your understanding of medical necessity aligns with what's in the contract, because they could change it and make it different. So coming back to how we deal with the issue of an auditor, a contractor, or a third party payer coming back and denying your claim for medical necessity, you have to look for the clinical justification, clinical necessity, the documentation of that. Take a look at, again, national coverage determinations and local coverage determinations. Have there been, these are rules that will be drafted by CMS or by its contractors. A little bit of a distinction here that folks should be aware of as well. And we may dive into this another time where we can take a little more of a deep dive into some of the rulings on these. National coverage determinations are issued by CMS or its contractors, typically the MACs, and these are binding. And what that means is they're like you have a statute, you have a regulation, and then you have a national coverage determination, which essentially provides further detail on what types of services will be allowed and what the requirements are for their services, and what types of things won't be allowed, which won't be deemed to be medically necessary. Then you have, if you don't have a national coverage determination, you may have a local coverage determination, an LCD, which is typically always going to be prepared by a contractor who's interpreting Medicare regulations. And a lot of folks don't realize this. The local coverage determinations, while they are considered persuasive authority on reviewers, on an ALJ, on administrative bodies, and on courts, they are not mandatory authority. And what that means for the non-lawyers is that a court doesn't have to follow it. If you get to round 5 in your appeal process with Medicare, and you're dealing with questions over a local coverage determination, a court will be required to follow as mandatory authority a national coverage determination, but not a local coverage determination. So a court can look at it and say, okay, we find that that influences our decision and we agree with it. But a court can look at it and say, we understand that it's persuasive authority, but we don't have to follow that. A judge at the federal court level does not have to follow an LCD. So that could make a difference. If you're looking at an LCD that doesn't make sense, or if you have an argument involving the interpretation of a certain service and you are representing somebody, or if you're a provider of services and you're convinced that you did everything right and the services should be paid, and you have an LCD that runs counter, you are running uphill if you challenge it, but it's not impossible. It's not like running against the statute or an NCD. So I want folks to keep that in mind, and maybe probably some dry material, but what might be interesting to take a look at some instances where local coverage determinations have been challenged and people have had success, so you get an idea what the standard is, what's required in order to do that. We also, and I'll talk in the next slide too about treating physicians. There's legal authority in the cases where the courts give deference oftentimes to the treating physician, because the idea is the treating physician is in the best position to understand what the medical necessity is. A reviewer and auditor didn't have the benefit of seeing that patient, so they're not in as good a position to determine medical necessity. So rightfully, we should give deference to whoever the treating provider was. And that has given rise to what is known generally as the treating physician rule. However, there are some instances where, again, most of this is in Medicare with CMS, has essentially rejected the treating physician rule. And there's some rulings. There's one from not too long ago where CMS essentially said we don't follow the treating physician rule. What's interesting is those CMS decisions are binding among in the administrative system in their appeal process. But again, once you get to federal court, the federal court doesn't have to follow it, because the federal court's going to look to persuasive decisions, which are those of CMS, those of its contractors, and those of other courts that aren't binding on that court. But a court could run counter to the position of CMS after you lose 4 rounds of appeal once you get to the federal court level. Of course, time consuming and expensive to get there. CMS has created an uphill battle, but it's possible. And finally, with medical necessity, going back to this question of whether or not if you have clinical necessity and maybe your documentation is not as sufficient as it needs to be, can you supplement it? Is there a way that you can correct that issue? Again, not making up records, not changing the records, but is there some way that you can credibly and honestly supplement the documentation in order to support medical necessity and support your appeal? And keep in mind, again, in Medicare, you need to do that at level 2. If you don't do it, you're going to be out of luck. But this comes up quite a bit. Again, just think of the instance that I explained with just a simple plan of care with the signature that gets questioned. Is there a way we can go back and do something later to supplement the record, provided additional affidavit or sworn statement by the physician stating this occurred and this happened and I signed this form, etc., to correct the issue going forward and enable you to get paid. All right, I just talked about the treating physician rule. There was some talk where it was removed officially from Social Security regulations a few years ago, but again, among the courts will still oftentimes give deference to the treating physician when it comes to questions of medical necessity, as long as there's nothing barring them, such as a national coverage determination that prohibits payment. It's still an argument that you can raise. So it always should be something that you're considering raising if you're going through the appeal process. So talk about some other issues here. One is the application of an improper standard. So the case that or that excerpt from the case that I read to you a little bit earlier, and when I first started the seminar, that comes from this this Burwell case. And what happened in this case is that CMS rejected certain claims that were submitted for, I think it was physical therapy services. And they rejected it based on a rule that had gone through changes. And at the time the services were provided, so the service, let's say the services were provided, I think it was in that case like 2008, and then CMS had amended the regulation in 2009 or 10 and applied that standard to reject claims. And the court in that case said, besides the fact that the description of the constantly changing and the pile of new regulations, laws, and sub-regulations, the fact that they were not only so voluminous, but changing at such a rapid pace that CMS didn't seem to understand the standard that should apply at the time that its contractor denied payment for the services. And so this is something that you can always take a look at. Is the contractor or the auditor applying the proper standard, the proper legal or proper review standard for payment? And is it proper for the time that the services were provided? So an example we might have is if you're dealing with an issue of a recoupment demand based on a post-payment review for records from 2021 and 2022, CMS or its contractors can't use or they shouldn't be using some regulation or an LCD or some other type of authority that was generated after those services were provided. Now, there may be an argument there that, well, those services were never payable. We just issued a decision later, or this NCD was issued later to make clear that those services aren't payable. However, if there's any ambiguity, and this goes for commercial insurance, for any payer, they can't raise the issue, raise a contract issue, raise a statute regulation that came about later to deny services that were provided prior to the time that law went into effect. Think of it, the average layperson would think of it as something being grandfathered in, services that occurred before the law changed. And that's essentially what this Burwell case is talking about here, is the courts can't apply, or the auditors can't apply an old standard or a not yet imposed standard to deny payment. Interesting language here out of the Social Security Act. just about essentially innocent errors made by providers. I don't know how much it really comes up, but it's a useful tool to have in your toolbox if you're trying to challenge any auditor results, adverse results, and maybe look at the cases that cite to that statute. And when you go and you look at the legal authority that cites to that particular code section in the U.S. Code, that might give you some recent decisions that could be helpful. So that's a way to sort of back in and go do research for yourself to find situations where a provider or a provider of service was successful in challenging, based on essentially equitable grounds, the decision of an auditor. Similar language consistent with the last statute, that a provider will be able to argue and may have a chance of success at arguing that the payment was denied, and essentially what this is all saying is that it was unfair, either due to the timeliness of the demand. If a certain amount of time passes and the auditor has not made a review on a demand for payment, you may be past a certain limitations period. Or if these other standards apply here, and you can see I took some language that a demand will be deemed against equity and good conscience if an incorrect payment was made for expenses incurred for items or services to which the payment may not be made under this title by reason of certain provisions in the code section, or if by the Secretary's determination that such payment was incorrect and was made subsequent to the 5th year following the year in which the notice of payment was sent to the individual, and there's some exceptions to that as well. So again, more tools to consider depending on your particular circumstances when you're challenging audit results. Pull out this case here. It's a couple years old regarding FCA false claims liability. So that's one of the things, and I probably should add that to the slide. You know, potential negative consequences of what can happen from an audit is you may have a claim for violating the False Claims Act, and that can lead to all kinds of other problems for as far as additional monetary damages that you could owe to the government. And in this case, the Boston Heart Diagnostics case, the issue was whether a lab had false claims liability for performing services ordered by the treating physician. And what the court essentially held in that case is that all entities have a responsibility to bill for services and be able to justify the services that they bill for. However, as far as submitting false claims, the court stated that you don't have False Claims Act liability, which is essentially where you submit a false claim to the government knowingly and you get payment for that, and you could be subject to particular monetary damages. You don't have False Claims Act liability when reasonable parties can disagree over whether the services were proper and whether the services were properly billed to the government. And you may not have False Claims Act liability when, even though everybody in the chain, if a physician refers services to a lab or for some other services, and those services are provided and found to have been improperly provided and paid, everybody in that chain doesn't necessarily suffer False Claims Act liability because they didn't independently verify. So if you're a provider, let's say you have your MRI company or you're a lab company, and you provide services based on a referral from the physician, if it turns out that the physician was acting in a way that violated the False Claims Act, it doesn't necessarily mean that you're going to be stuck with the same issue. You see this sometimes in federal cases that might be RICO or conspiracy cases. Just be aware that I threw this in because I have a recent situation and I'm dealing with a client with a very similar situation where the client was providing services, but one of the contractors, one of the other suppliers that the client was working with, it turns out that supplier lost its license. So then the question comes up, well, if the physician is referring and using a supplier who lost its license, does the physician who's making those referrals have liability. And the argument in defense to that, the first argument that we would evaluate in defense to that would be, well, what due diligence did the physician perform? What were they required to perform? Um, what was the situation when a physician, like for instance, if you start working with a provider and that provider is fully licensed, credentials, has all of the necessary credentials in order to provide that product or service, and somewhere along the line they're lost, and you don't have a further duty to independently verify that, maybe 2 months later or something, there's some set of circumstances with the time, does that provide you a defense to liability? And that's something you should always take a look at. So don't just think just because you get a demand letter from an investigative agency or some third party that says that you're liable for the fact that someone else dropped the ball. Don't think that automatically means that you're going to be in trouble as well. And we've seen that come up in a lot of cases. A few years ago, I was involved in a case involving several physicians and some telehealth companies and pharmacies and so forth, dealing with telehealth prescriptions. And oftentimes, whoever's conducting the audit or review will try to lump everybody in together. And you want to take a look at your own individual circumstances and see if it really fits that you're supposed to be lumped in with everybody else. All right, statistical extrapolation. This, for anybody who's not familiar with what this is, essentially occurs when there's a post-payment review of claims. The auditor will get a certain number of claims to review, and if the error rate is particularly high, generally over 50%, then the auditor may conduct what's called a statistical extrapolation to say, okay, if you've had 80% error rate on these 50 claims that we reviewed during this time period, we can extrapolate from that you had an 80% error rate over these several years, and this is the amount that you owe. And that's how you get a review of a relatively small number of claims that turns into $1 million or more recoupment demand. If you're dealing with this, this is one of these ones that you really should consult with an attorney pretty quickly, because you've got a serious issue on your hands. If you get an extrapolation, a recoupment demand that's 6 figures or more, it's likely the result of this process, and you need to go through all the processes that you can through the appeal process to try and challenge that. First thing you'll be wanting to do is challenge the results on the initial claims, but there's other ways to challenge it as well, such as what the actual sampling process was. The statistical process, it may require you to engage the services of an expert in statistics or in some other area. But I want folks to be aware of that if you see this demand for $800,000 or $1.5 million based on a small sample, it's no joke. So when can an auditor extrapolate? Well, this is interesting because obviously in the federal system, Medicare, there's an extrapolation, there's guidance and there's a process. Again, generally, if there is over 50% error rate, then the contractor can extrapolate and demand a higher amount of return on the recoupment. Under the targeted probe and educate system, that's a different auditing system for Medicare, the error rate can be lower. The contractor can also look at the provider's history of non-compliance for the same or similar issues to see if there's a historic non-compliant billing practice issue and use that as justification for extrapolation. The takeaway out of this is that it's not set in stone. So if an auditor is trying to extrapolate, don't just accept it at face value. Consider everywhere where you can challenge it, including the right to extrapolate. Example of that is in Medicaid. Can an auditor in Medicaid extrapolate? Well, I had a client a couple of years ago where it was a commercial managed care company administering Medicaid in Florida that used an extrapolation process to make a demand on my client for upwards, it was almost $700,000. And we challenged the underlying basis for the denial of the claims that gave rise to the extrapolation. but we also challenge the right to extrapolate itself. I'm not convinced that, at least in this particular circumstance where I looked at it, that the company had a right to engage in any type of statistic extrapolation. I had that issue that came up again, looking at something with a surgery group, where a commercial insurance company sent a letter, and it was like a one-page letter. It almost looked to me, if I didn't know that it came from the company, I would almost question the veracity of the letter. But the letter said, "We've reviewed your files over the past year for these particular submissions, and we've determined a higher error rate. And because of that high error rate, we've extrapolated, and you have to send us," and it was some crazy six-figure number. And right away, that the whole thing looked strange to me. They didn't give details on what claims they reviewed. They didn't give details on why those claims were denied. It was literally a one-page letter seeking several $100,000s, purportedly based on this extrapolation. So be careful of that. If you're seeing that anywhere else besides in Medicare, you should question the authority of that process to begin with. Judgment error: if the insurance company approves a claim, is mostly with commercial payers. If a commercial payer approves a claim and later it seems like it changes its mind, or if it's been paying claims and suddenly stops paying them, the insurance company can't pay and without notice decide that it's not going to approve claims without a sufficient basis for doing so, and normally has to give notice ahead of time. There should be some policy or regulation. Anytime you're dealing with this issue, you should always question the authority under which any type of demand for payment or withholding of payment is being made. Injunctions pending appeal. I wanted to include a little bit of a discussion. We've only got a couple minutes left, but I wanted to include a discussion just to have it out there so you're aware of the potential and what the process is for the situation where you're going through, again, this is mostly Medicare, because this is where we see it, where we see the 5-level appeal process, and you're going through the first 4 levels, you're going through that administrative process, and sometimes this can take many months into years to go through that appeal process. And you have your level 1 redetermination, your level 2 reconsideration. There may be, during that time, there's a recoupment demand. And then if you're unsuccessful at level 2, you have level 3 at the ALJ, but the contractor may start acting on the recoupment. And, again, we could talk hundreds of thousands of dollars here. The contractor starts recovering money, and you're still going through the appeal process. And how do you halt that? How do you halt them from either collecting from you, or where it usually comes is in the form of an offset? So now you're providing services for the beneficiaries and you're not getting paid. There are cases where parties have attempted to go to the federal courts and get an injunction. And basically the argument sounds like this: yes, we're going through this appeal process in the administrative system, but until that process is completed, the auditors and the contractors should not be entitled to act on the recoupment until we've exhausted the entire appeal process, and we have a definite determination that that money is due. And usually this comes in the form of a contract or a provider stating that this is going to be years to go through this process, and if you recover this money, or if I can't get paid for these services going forward, I'm going to be out of business. And so the appeal process doesn't matter. You're going to put me out of business before I ever finish my right to appeal. You have to argue that there's a property interest in the, you have to argue, one, that the court has authority and jurisdiction to look at this issue. And the basic requirement to make that happen is that you have to be in the process of exhausting all of your remedies during the administrative process. If you abandon that, then your argument will fail at the federal court. So one, you have to be exhausting all the administrative processes, and sometimes you get held up at the ALJ. So then you have to look at whether it makes sense to bypass the ALJ, which you have a right to do, and go to the 4th level Medicaid or Medicare appeals. So one, show that you have jurisdiction at the court, and 2, show property interest in the payments that are being withheld because of the recoupment offset. And the courts are split on this. There's a middle district court case from a couple of years ago where the judge at the middle district said that because those payments that you get under Medicare are contingent, you have a contingent right to those, they could be recouped, they could be reduced, they're not a property interest. Other courts have held that it is a property interest, and you can't deprive a person in the United States under the federal Constitution, you can't deprive them of their property without fair hearing, a fair opportunity to be heard. And so that's essentially what the argument is that until we go through this administrative process, you can't take my property. That I provided the services, I'm entitled to be paid, and I'm entitled to the money. Those attempts have been met with mixed results. I put it out there to let you know that that argument is potentially available. Probably in each individual circumstance, you really have to take a look at the facts of your case. Take a look at where you are in the U.S. What jurisdiction are you under? You may have a different result. For instance, if you're in Texas versus if you're in Florida or if you're in California, what's the federal court? What recent rulings have come out? And then evaluate it from there. And maybe again in a future seminar, maybe we'll dig into some of those cases. But it is possible, by the way, that you may be successful in getting an injunction against a contractor to be able to offset your future payments for services for beneficiaries while you're going through an appeal and dealing with an appeal of a recoupment demand. You may be able to put that off, and ultimately, if you're successful in the appeal, of course, then you get to keep the money anyway. Finally, a few tips here as we close out. I'll be willing to take any questions right after, or if you email me or call me. Again, first thing we talked about with appeal, consider the cost-benefit analysis. What is time, money? It may not make sense to appeal the denial of a claim that's $1,000, depending on what's involved in it, or it's a few $100s. But when you're talking about many claims, the calculus changes, especially if you're looking at a potential situation that could lead to further adverse results or further audits that could lead to extrapolation situations. Also, I throw this out there as well. Check with your insurance carrier. If you get hit with one of these audits, some insurance provides for covering the defense costs. They obviously won't pay for any recoupment, but there's insurance companies that cover the defense costs. If you have questions about that, contact me. So you should always look at your policy, very similar to maybe like licensed defense, and they'll pay for the defense of your recoupment or audit. And then finally, another point I want to leave you with, again, is when you're going through this process, evaluate the medical records carefully and figure out if something was not in the record that can be supplemented, and make sure you do that at the proper time so you don't waive that argument. In my view, always better to supplement if you can, put any information in that you can as early as you can, and if it gets rejected, no harm, no foul, as long as you're not altering records and as long as it's not dishonest. And with that, if there's any questions, we can field those, and otherwise we'll look forward to seeing you on the next one.